Hi, welcome back. In this session, we are going to discuss about unfair labor practices under Industrial Disputes Act 1947. The expression unfair labor practice has been defined in the Industrial Dispute Act 1947 as any of the practices specified in the fifth schedule, but Section 28J, Section 28E, and Section 32D of the Indian Trade Unions Act 1947 give a list of unfair labor practices found in the labor field. So that is Section 28 Clause J, Section 28 Clause E, and Section 32 Clause D of Indian Trade Union Act 1947 plus the fifth schedule of the Industrial Disputes Act 1947. So these two give us an idea about what are the unfair labor practices. Now, unfair labor practices usually found on the part of a recognized trade union are as follows. A. Taking part in an irregular strike. B. Wrongly advising the employees to commence an irregular strike. C. False statement made by the union in terms. So that is with the unfair labor practices usually found on the part of a recognized trade union. Now, unfair practices by the employer. So here, A. To interfere with the rights of the trade union. B. To give benefit in a discriminating manner. C. To take disciplinary action against any workman on the ground that he has given evidence against the employer in an industrial dispute. D. To threaten employees with discharge or dismissal when they join a union. E. To threaten a lockout. F. To encourage or discourage membership in any union. G. To correct the seniority list in a discriminating manner so as to favor members of a union. Now, H. To give unmerited promotion to certain employees. I. To discharge office bearers or active members of a trade union on account of trade union activities. So these are the unfair practices from the part of a employer. Now, general unfair labor practices. In that, to discharge or dismiss an employee by way of victimization. Victimization means that an innocent worker is punished because he has in some way displeased the employer. The second meaning is that where an employer who has committed an offense is given a punishment disproportionate to the gravity of the offense because of his trade union activities. So, we have a case law, that is National Tobacco Company Limited, India versus Industrial Tribunal. Here, the Supreme Court held that punishment is shockingly disproportionate to the circumstance. So, that is also a mode of victimization. So, that is held in National Tobacco Company, India Limited versus Industrial Tribunal. In another case, that is Eveready Flashlight Company versus Labour Court. That is Eveready Flashlight Company versus Labour Court. A workman was appointed in the company on a daily rate wage for 4 days. On April 12, 1958, he was appointed on probation for 6 months. He was elected a member of the working committee of the union. On 10th September, the management served a notice for improving his work, and finally he was dismissed. He had argued that the termination was an unfair labor practice. The Allahabad High Court held that it was a clear case of unfair labor practice. So that is the case of Eveready Flashlight Company versus Labour Court. Now another case law, that is LH Factories and Oil Mills versus State of UP. That is 1961. LH Factories and Oil Mills versus State of UP 1961. Some of the workers were promoted to the rank of driver cum assistant fitter. 2 workers who were senior in service and also better qualified were not promoted. The court held this amounted to victimization. Now another case, that is Hind Construction and Engineering Company case, that is 1960 case. Here, it was a custom in the company that when a holiday fell on Sunday, the next day was declared a holiday. In 1960, January 1st fell on Sunday, but the company refused to declare January 2nd as a holiday. Even permanent employees refused to work on that day. They were dismissed. The industrial dispute developed. The court held that the punishment of dismissal for 1 day's absence was harsh, unjustifiable, and amounted to victimization. So that is the case of Hind Construction and Engineering Company case. The Supreme Court observed that the punishment is shockingly disproportionate regard being had to the circumstance of the case. The absence of workmen on a particular day as such act of misconduct for which a lesser punishment like warning, fine or transfer or withholding an increment etc. might be imposed, but not dismissal. Now, the other general unfair labor practices will include avoiding payment of statutory dues and transfer of an employee malafide. Industrial Disputes Act, Section 33, Subclause 2, Subclause B. In Jaipur Zilla Sahagari Bhumi Vikas Bank vs. Ram Gopal, 2002, the Apex Court ruled that conditions contained in the proviso to Section 33, Subclause 2, Subclause B are mandatory in nature and their non-compliance would render the order of discharge or dismissal void or inoperative. It was further held that if the tribunal refuses to grant approval sought for under Section 33, Subclause 2, Subclause B, the effect of it shall be that the order of discharge or dismissal had never been passed and consequently the employees would be deemed to have continued in service, entitling him to all benefits available. The above decision was reiterated by Supreme Court in Indian Telephone Industries Limited versus Prabhagar H. Manjara, that is in 2003. So that is the end of the session. Thank you for listening. Like, comment and subscribe. And don't forget to click that bell icon so that you get an update when I upload my next video or a podcast. Thank you.